My name is Andrew Fisher, and I'm here today having a conversation with Professor David Benatar about assisted dying. I'm going to introduce myself first, and I'll let Professor Benatar introduce himself, and then we'll kick off. As I said, my name is Andrew Fisher. I have a master's in philosophy from UCT, as well as a law degree, and I practice law in Cape Town, but I also have an interest in important questions at the intersection of practical ethics and law. And the questions and topics around assisted dying are in my area of interest. And I'll let Professor Benatar introduce himself, and then we'll kick off.
Thanks very much, Andrew. I'm David Benatar, and I teach in the philosophy department at the University of Cape Town. I have interest in a number of areas, but most especially in applied ethics, and assisted death is one of the topics I'm interested in.
Thanks very much, Professor Benatar. Would you like to kick us off just by explaining what you mean by assisted dying? Because there are a number of different concepts and terms that we need to distinguish, and it'd be great if you could just clarify those for us.
Thanks. Yes, you're quite correct. So there are a number of terms that one might use. Euthanasia is one. Euthanasia is when somebody's life is brought to an end for that being's sake, and it's brought about by somebody else. Assisted suicide is when one takes one's own life and with the assistance of others. I understand assisted death to be an overarching term that would incorporate both of those. So if you're taking your own life with assistance, that's one form of assisted death. Whereas if somebody is taking your life, let's say with your request, then that's another form of assisted death.
Okay, so by assisted death or dying, you're using that to encompass both assisted suicide and euthanasia.
Yeah, so that's where I understand it. I imagine
Yes.
there might be other ways of interpreting it as well.
Okay, good. And just to be clear, so I will use assisted dying in the same way in this conversation, unless I'm specifically referring to either assisted suicide or euthanasia, then I will do that. Professor Benatar, could you say something about the distinction between voluntary and non-voluntary euthanasia?
Yes, that's another important distinction. So if somebody's death is being brought about for their sake, they may be of two kinds. The being might be of two kinds. The one is a competent being and the other is a non-competent or incompetent being. So the most common form of a non-voluntary euthanasia is really in the veterinary context, where animals are put to death, often but not always for their own sake, because they've reached a point in their life where they're suffering unbearably, and the only way to avoid that is to terminate their lives. They're not capable of making these decisions for themselves, and so somebody else has to make that decision for them. But it is also possible to have non-voluntary euthanasia in a human context, with, let's say, a young child who's unable to make those decisions, or somebody who has become senile and is unable to make those decisions. Voluntary euthanasia is where you've got a competent being. This is somebody who's able to decide for themselves whether their continued life is in their interests or not, and then they make the decision, they authorize the death.
Okay, good. Thanks very much for clearing that up. And I think there are a number of different questions or ways into the topic of assisted dying, and I would like to just briefly outline three distinct questions that we could ask and that we will explore in this conversation. The first is whether assisted dying is morally permissible, and that's a normative question, whether it's morally permissible if in any circumstances, and if in any circumstances, in which circumstances. The second question is whether it is in fact legal, and that's a very different kind of question. It's what's called a descriptive question. It's a question about what is the case. And given my legal background, I can speak to that. I can speak to the legal status of assisted dying in South Africa and in some other comparable jurisdictions. But just to be clear, that's a very separate question from the question of whether it's morally permissible. And then the third question is whether it should be legalized in a particular jurisdiction. So, for example, in South Africa, should assisted dying be legalized? And that's a normative question as well. So, ought it to be legalized, morally speaking? So those are three very separate questions, which it's good to keep distinct in one's mind. And Professor Benatar, I wonder if you wouldn't speak to the relationship between those questions.
Right, so a lot of people think that if they are in favor of or against something like euthanasia, then they must take a view both that it is immoral and also that it ought to be illegal. But I don't think one has to have that compatibility of view. So it could be that, or congruence of view, it could be that you believe that euthanasia is morally permissible in some circumstances, but that it ought not to be legalized, perhaps because there would be various negative effects of legalizing it, and we can discuss that in a bit more detail later. Or it's possible that you believe there's something morally wrong with euthanasia, and yet you nonetheless think that it ought to be legally permissible. And one possible basis for that is that you recognize that there are competing moral views about this, and you might believe it's inappropriate for the state to interfere in the freedom of somebody who thinks it is acceptable, even if you think it is unacceptable. So those are ways in which those two questions come apart. Obviously, the intermediate question that you mentioned about whether a practice is legal, that's, I think, less likely to be confused with the other two, although there are people who do make that confusion.
So the case where someone might think that assisted dying is not morally permissible, but nevertheless ought to be legalized. Would that, so maybe we can clarify that with an example. Would an example of that be perhaps, or analogous example, where we think that some forms of speech are maybe not morally permissible, but we don't want to criminalize them, or they ought not to be illegal? So, for example, some forms of offensive speech, because we think that the state shouldn't interfere with people's freedom of speech unless it's causing harm to others. Would that be a kind of a clarifying example of that sort of category?
Yeah, I think that's an excellent example. So when you're giving or permitting a legal right, allowing a legal right to freedom of expression, one recognizes that it won't always be used in a morally appropriate way. Sometimes people will say things that they ought not to say, but you don't think that they ought to be criminalized as a result of that.
And I suppose the other category, so let's think of an example where someone might think that assisted dying is morally permissible, but it ought not to be legalized. Could you maybe give us an example of a case that would fall in that category?
You mean a different kind of case, where something that's not euthanasia?
Oh no, actually. So I suppose one way of thinking about that would be, so we think it's morally permissible in certain circumstances for a doctor or appropriately qualified person to assist someone to commit suicide, for example. But we don't think that it would be a good public policy to legalize it for some other reason or category of reasons. So the particular circumstances or jurisdiction in which we're operating is not conducive to it being legalized in particular circumstances, for example.
Yeah, so that's one common argument against the legalization of euthanasia, is that if one were to permit this, then it would be abused, one would fall down a slippery slope and begin to permit more and more forms of killing. And so even if you thought that there were some instances of euthanasia that were morally permissible, the worry is that if you allow it, you will not be able to stem the tide, that all kinds of impermissible actions will then take place. Now, of course, that's an empirical claim, and we can evaluate it perhaps later, but that is an argument which is very regularly advanced against euthanasia and the legalization of it. Although I should say that it's most commonly advanced by people who do think that euthanasia is immoral, and they're looking for an argument for why it ought also to be illegal. But in principle, it could be advanced by somebody who thinks that it's morally permissible.
Okay, I'm with you. So I think that's the distinctions between the questions are quite clear now, at least in my mind. So thank you for clarifying those.
Thank you.
Can we dive into the first question, which is under what circumstances, if any, assisted dying is morally permissible? And yeah, maybe you could take us through some arguments for that position.
Right, so here I think the distinction between the voluntary and the non-voluntary is very important. There are overlaps between these two arguments, but perhaps let's focus for simplicity first on the case of voluntary euthanasia, because in some ways that's clearer. And we may or may not get to the case of non-voluntary euthanasia. So what's going on in voluntary euthanasia, just to remind everybody, is that there is a competent person, and by competence here we mean somebody who's able to make this particular decision, a decision about whether continued life is in their interests. And they've reached the conclusion that it's not. And let's say there's somebody who's willing and able to assist them, and the person who's suffering is able to provide a good argument, compelling reason to the potential assister that continued life is no longer in his or her interests. It seems as though that person ought to be entitled, or they are entitled, put it this way, morally, to end their own lives. Now, some people say if you want to advance that argument, you need to postulate a right to die. My own view is that you really only need to postulate a right to life. Because the thing about a right is that the right holder can waive the right under certain circumstances. So let's imagine that you own some property, let's say a watch. You have a right to that watch. That means you have a right that other people not use it or take it without your permission, but you can grant permission to people to use it, either in the short term or in the long term. And so what you're doing is you are waiving the protection of the right in certain circumstances, or you might alienate the right entirely and give the watch to somebody else. And similarly, I'd say with a negative right to life, a right not to be killed, you need to be able to waive that right. Now, there are different theories of rights. Some theories of rights say that what rights are doing is they're protecting interests. If you adopt that view, then you have to say that you have the entitlement to waive the right, because otherwise, if continued life is no longer in your interests and you're not allowed to waive the right, then the right is now going to no longer serve your interests. If the very point of a right is to protect your interests, here it's going to be thwarting your interests. So inherent in this claim of the right not to be killed is the entitlement to waive it. If alternatively you go with another view about what the purpose of rights is or the function of rights is, if you say that their function is to protect choices, then again, it has to be the case that you can choose whether or not to live. And if you've reasonably reached the conclusion that it's not in your interest to continue living, then the right to life would also enable you to waive that right with respect to somebody who's willing to help you end your life.
Okay, so whether you take an interest-based theory of rights or a choice-based theory of rights, is your view that you have a right, if a right to life based on either of those theories is assumed, moral permissibility to assisted suicide or euthanasia follows from that right to life.
I think so.
In broad, fair representation. Yeah,
I think that's correct. There's one feature of this that I've glossed over. So if you're getting assistance from somebody else in taking your life, then I think there is an epistemic hurdle that has to be passed. So you need to be able to demonstrate to the person providing assistance that this is warranted, that continued life is no longer in your interest. So convincing yourself is one thing, if you're taking your life without any assistance. But if you want to get assistance from somebody else, you're going to have to reach a higher epistemic bar, exceed a higher epistemic bar, and demonstrate to somebody else that this is appropriate.
Right, that makes sense. So there's, is it fair to say that there's some sort of, in the case of assisted suicide, the person who wants to avail themselves of assisted suicide needs to provide some sort of compelling reason to the person who's assisting. So there brings a sort of element of objectivity into it, in terms of there has to be some compelling reason.
I think so, yes. And I think it would be irresponsible of somebody to assist in a suicide without that sort of evidence. So if somebody just said, help me kill myself, and you rushed in and you helped them kill themselves, that would be deeply irresponsible. Right. Whereas if you saw that somebody was in extremis, that there was little else that could be done, or perhaps nothing else that could be done to secure their interests, and you're convinced of that, then it becomes a much more reasonable course of action.
Right. Do you have a preference between the interest-based theory and the choice-based theory of rights?
Well, I don't think we need to choose between us. I think whichever one you choose, it's going to lead to the same conclusion. So perhaps it's best if I don't take a stand on that now, especially since it doesn't make a difference to the argument.
Great. And do you think you can support the moral permissibility of assisted dying in certain circumstances without invoking a right to life at all? Is that possible?
Yes, because I think you can say that independently of a right, if somebody no longer has an all things considered interest in continuing to live, then death may be the least bad option for them. And if they're unable to do that unassisted, then it may be the compassionate thing to do to help them. So I don't think you have to appeal to a right. Okay,
so there's a number, at least two different routes to the conclusion that it's morally permissible in certain circumstances. And maybe we could just take a step back here and say, in your view, Professor Benatar, what is the appropriate scope of morally permissible assisted dying? So in which circumstances would you think that it is morally permissible?
Right, so here we get into more controversial terrain. I think the clearest cases, these are not cases that everybody would agree with, because obviously there's some people who are categorically opposed to all euthanasia and assisted death. But the cases that are going to be least controversial are where somebody has a terminal disease and they're suffering unbearably. So the expected life remaining is very little, the quality of life is very poor, and then I think most people who are not categorically opposed to euthanasia would permit it, would think it's morally permissible in those circumstances. More controversial next is where you have a condition that's not terminal but is unbearable to the person whose life it is. And then I think some people get a little more nervous. I do think that those cases are still instances where assisted death is warranted. It's the fact of its unbearability and the fact that you can't avoid it any way other than death that I would say makes assisted death in those cases reasonable. The most controversial cases, I suppose, are when one's dealing not with a physical ailment, but with a psychological pain. If somebody, let's say, is depressed and they're unresponsive to treatment, they can't get the psychic relief that they want, they find continued life unbearable, but they're bodily healthy, and they want to die. Those are going to be the most controversial cases. And I think for good reason they're most controversial. I would not want to categorically rule all of those out, but I would want to demand a very high level of proof, let's say, that this condition was unresponsive to treatment, that there was no other way to alleviate the person's condition, that it really was unbearable for them. But I don't see any inherent reason why we should treat psychic pain as less serious than somatic pain.
Yes, I mean, it seems what at root, what's kind of at the base of the issue here is the interest in alleviating suffering and recognizing that suffering need not be physical suffering only, it could also be mental suffering.
Yes, I think it's partly suffering, but one common response that opponents of assisted dying have is that one can always palliate a condition. They're thinking primarily of physical conditions, but you can always render somebody barely conscious so that you avoid the actual suffering. But many people who seek assisted death do not find that to be an acceptable outcome. They don't want to live in that kind of condition, that kind of state. So they would rather be dead. And so I think it's not just suffering. Suffering is the one thing, but the other is being reduced to a level of dependence, of unconsciousness or semi-consciousness that's not acceptable to the person whose life it is.
Yes. So there's an interest in avoiding suffering, but also some sort of interest in autonomy, or being able to be living according to one's own lights, with full mental faculties, and to be able to be with one's loved ones at the time of one's death, etc. That going into a conscious sedation state or with some forms of palliation just wouldn't be conducive to.
Yeah, I think that's right.
And so what about some people who, there are some people who have the view that human life is a gift of God, and it's not ours to decide when to take away life. I suppose one sort of term for this, a family of views, is the sanctity of life, or views that are based on an idea of sanctity of life. So in my understanding, this could have a religious form, but also a non-religious form. But the basic idea is that there's some sort of intrinsic value to human life, which makes taking an innocent life or killing an innocent person categorically wrong in all circumstances. What would you say to someone who has such a sort of sanctity of life type view?
I think it may be helpful to distinguish two versions of that kind of view. So one view thinks that the mere continuation of life is a good thing, no matter what the condition or the quality of that life. So more is always better than less. And then there's another view which you also described, which is that irrespective, I think, of whether that's true, it would be wrong for us to take a life, or at least a human life. In response to the first view, I would argue that I don't think most people really believe that. I think they might sometimes say it, but they don't really believe it. I find that when I present people with the following choice, I get a fairly unanimous answer. So imagine that you could have two choices. Either you live to 80 and then you have a stroke and you die instantly, or you live until 80, you have a stroke and you're reduced to either an unconscious or a semi-conscious state. You continue to live biologically, let's say, for another 10 years, at which time you have another stroke and then you die. If I ask people which of those they would choose, whether they've got any preference between them, almost everybody I speak to, maybe I'm not speaking to enough people, but almost everybody I speak to say they would prefer the first option, where they die instantly, because they just don't find the additional increment of 10 years of semi-conscious or unconscious life to be of any value. Now, of course, people's intuitions would just be completely mistaken about this, but if they are correct, that seems to suggest that the idea that every extra moment of biological life is somehow valuable does not have much going for it. And if you did think that every moment of biological life has value, then presumably you'd need to think that also about plants, which merely have vegetative life. Is every additional second of that life valuable? And then if we turn to the version of the argument where it involves taking the life, look, it's very hard to argue with people's religious beliefs. If that's what they believe, it's hard to convince them otherwise. I suppose one thing one could do is to point to inconsistencies that they might have between an attitude to human life and to real vegetable life. But again, they're going to just appeal to a religious text which speaks about the importance of human life and not a vegetable life. So it's going to be really hard to convince. But I suppose what I would say is that those are undemonstrable views. These are not things that you can demonstrate to other people. I certainly would not want to override somebody who had those views. If that's the decision they're taking for themselves, that's the decision they're taking, and I wouldn't seek to overrule it. But if they are wanting to make an argument to other people about what other people should be doing, they need to recognize that the premises of their argument, or at least one premise of their argument, is not something that can have a reach over those who do not accept the assumptions.
Yes, I'm with you on that. And I'd like to speak more about this when we get to the question about whether assisted dying should be legalized, because so there's a feature of that question which is, I suppose, different from the question of whether it's morally permissible in certain cases, is that when you're talking about whether a particular public policy is justified or to be implemented, you need to take into account groups of acts, not just individual acts. So
correct.
when we're thinking about the question of whether it's morally permissible, we can talk about individual cases in which it is morally permissible. But when we're thinking about whether it's a good public policy, we need to think about, so notwithstanding that some people might have strongly held religious views opposed to the moral permissibility or even the legal permissibility of assisted dying, does that mean, or to what extent do we take that into account in a liberal democracy in deciding what a good public policy is? So I'd like to talk more about that when we get to that question, if you don't mind.
Yeah, that sounds good. But perhaps in the meantime, you should tell us a bit about what the legal situation is, both here and elsewhere.
Yes, happy to do that. So I will address the descriptive question of the legal status of assisted dying. Of particular relevance will be the legal status in South Africa, but I think it will be useful also to compare it to some other jurisdictions. So in South Africa, the current situation is that assisted dying, both assisted suicide, doctor-assisted suicide, and voluntary euthanasia are not legalized. They are currently illegal. So there is no statute in South Africa at the moment which legalizes these practices. There was a case in 2015 which was heard in the Pretoria High Court. And the applicant in that case was a man by the name of Mr. Stransom Ford, and the High Court in that case granted Mr. Stransom Ford the right to be assisted to commit suicide. And in his circumstances, he was terminally ill with cancer and experiencing extreme physical suffering. So the High Court granted him that order, but it's important to realize that that was in very specific circumstances. And what in fact happened was that before the order was granted, Mr. Stransom Ford sadly passed away. And the High Court order was appealed to the Supreme Court of Appeal, and the Supreme Court of Appeal overturned the initial ruling in the quota quo, which means that the current status has not changed in the common law. By common law, I mean the law in South Africa that is developed by court cases that are handed down by judges because of the overturning of that initial High Court order by the Supreme Court of Appeal. But what's interesting about that case is that the High Court judge appealed to the Constitution, in particular the right to dignity in Section 10 and the right to bodily integrity, bodily and psychological integrity in Section 12 of our Constitution, in grounding his order, his conclusion that in these particular circumstances, Mr. Stransom Ford was entitled to be assisted to die. And I think that that's interesting because my own legal view is that in principle, and I must be clear about this is an in principle view and not an all things considered view, the legalization of assisted dying in South Africa would be consistent with the principles of our Constitution. So I'm not saying that's not an all things considered view. It's quite a narrow, circumscribed view that if it were to be legalized by statute or otherwise, or by the development of the common law in South Africa, I think that would be consistent with the principles of our Constitution.
Perhaps I can ask you the flip side. Let's imagine it were actively rendered illegal by the legislation and that were challenged. Would that be inconsistent in principle with the Constitution? Yes,
my view is that it would. And so what's interesting here is a comparison with Canada, which also has a constitution as a charter of rights, like our Bill of Rights. And in that jurisdiction, in the case, so there was a case in 2015 in the Supreme Court of Canada, Carter v. Canada. The Supreme Court ruled that the blanket prohibition of assisted suicide was inconsistent with the Section 7 Charter right to life, liberty, and dignity. So I think, and my view is that, using that as a comparison, I think that you could make a similar argument in South Africa that a blanket prohibition of assisted suicide would be inconsistent with, amongst others, rights in the Bill of Rights, the right to dignity and the right to bodily and psychological integrity. And what happened in Canada is that once that ruling was made, the court gave the legislature a certain amount of time to actually pass a federal statute which legalized assisted suicide, which has since been passed. So the situation in Canada now is that both voluntary euthanasia and assisted suicide are legal, again, in certain circumstances. So they're very, very clear criteria, eligibility criteria for availing yourself of doctor-assisted suicide. And I'll speak more to that later. But to answer your question, Professor Benatar, yes, I think that in principle, an overbroad, blanket prohibition on assisted dying in South Africa would be an overbroad limitation of certain important rights enshrined in our constitution. South Africa is a constitutional democracy, which means that the constitution is the highest law of the land, and all other sources of law need to be consistent with it.
Great. And can you tell us about some other countries, either where it's legalized or where it's illegal, remains illegal?
Yeah, so I think it's helpful also just to get a sense of the sort of the spectrum of different possibilities from a public policy point of view. So that's the case in South Africa. In the Netherlands, let's go to the Netherlands. So the Netherlands have had both voluntary euthanasia for mentally competent adults and doctor-assisted suicide have been legal there. I think since 2002, when or at least the statute was passed in 2002. But what's interesting there is that the model they have there is that doctors are immune from prosecution if they assist someone to die or they administer a lethal agent on request, given consent of a mentally competent adult. They are immune from prosecution in terms of the criminal code, provided that they comply with certain safeguards. And there's a very clear set of safeguards that have to be complied with. And what happens is that a case, either euthanasia or assisted suicide must be requested. The eligibility criteria must be met. And then it goes to a regional review committee to assess whether the due care obligations or requirements have been met. And if the review committee thinks that a due care requirement has not been met, then if it's a case of assisted suicide, or in either case, the person who administered, or the person who assisted, it can be liable for prosecution. So that's kind of how their model works. It's immunity from prosecution rather than a specific illegalization. And so what's interesting about Netherlands is that that statute has been enforced since 2002. So I think it's one of the jurisdictions in which these practices have been legalized for the longest amount of time. And that's useful because we can get a sense of empirical questions about what happens when you legalize assisted dying. And I'll speak a bit more about those later. But Switzerland has legalized assisted suicide, but not legalized euthanasia. Switzerland is the only country to accept foreign nationals for legal medically assisted suicide. And it's also, in terms of its criminal code, not a crime to assist someone with a suicide. And then I've spoken about Canada. So the situation there has recently become more permissive with first the Supreme Court case of Carter, and then piece of federal legislation which came through in June 2016, which allows both voluntary euthanasia and assisted suicide in very, very clearly defined cases. And importantly, I should also say that it's typical where assisted dying is legalized in some form that there is a right of doctors or other medical practitioners a conscientious objection right. So no one is forced to help any person to commit suicide or to provide
a willing dyer and a willing assister.
Exactly, yes. So I was talking about the United States. So there are a number of states that have legalized it at the state level. There's no federal cross-cutting federal statute which legalizes at the moment, but Oregon is a good example. They've had a statute in place for a long time now that allows terminally ill patients to avail themselves of doctor-assisted suicide, and again, that's where a doctor or a medically qualified person is allowed to prescribe lethal dose of medication, which is administered by the person wanting wanting to commit suicide. Yeah, in the UK, it's not legalized yet, despite some attempts to pass a bill by, I think, Lord Joffe through the UK legislature. So they still have not legalized that. So there is quite a range. In the Netherlands, it's been legal there for a long time, and it's probably important to note that over time, the types of cases the types of cases in which it's permissible, it's become more permissive over time. So, for example, in the Netherlands, there have been some cases where it has been permissible for people to avail themselves of assisted suicide where they're not suffering from purely physical suffering or terminally ill or are not terminally ill patients. There has been some debate recently about whether people who are just tired of life, who are older or above a certain age and just tired of life and not suffering from any demonstrable physical pain or suffering, but feel like their life has been completed, whether or not they should be able to avail themselves. That has not been formally resolved as yet. But I make the point just to indicate that the law has become more permissive over time. And we can talk about what that means. I mean, that doesn't necessarily mean that there's a greater risk of abuse over time. I mean, in one sense, it's obvious that if something becomes available and becomes legalized, people are going to make more use of it, and that perhaps over time, as a jurisdiction gets more used to it being available and legal in certain circumstances, the scope of morally permissible circumstances might increase. But that's not necessarily a bad thing. I don't know what your views are on that, Professor Benatar.
I actually had a few questions for you about this. So I think it's also worth just raising the case of non-voluntary euthanasia in the Netherlands. I know that's permitted there. Yes. They've got a protocol for infants, for example. Are there any other jurisdictions where non-voluntary euthanasia is legally permissible for humans?
For humans?
Yes.
I don't know off the top of my head, so I'd have to get back to you on that. But you're right. In the Netherlands, they have what's called the Groningen Protocol, which is a protocol setting out clear guidelines about when non-voluntary euthanasia may be indicated. And so a sort of case law or common law was developed in the Netherlands based on that protocol, which has allowed non-voluntary euthanasia in certain cases. But as far as I know, there isn't another jurisdiction, but I stand to be corrected on that. I'd have to get back to you.
Thanks. Yeah, I haven't heard about this, but I just didn't know for sure. I think we're verging now towards the final question we were going to look at about whether assisted dying should be legalized. But towards that end, let me just ask you some other questions about the legal situation. So you mentioned that the Netherlands has had legalization for quite some time. My understanding was that in Switzerland it's been legal for even longer. Is that correct or not?
So you're correct, yeah. So in Switzerland, it is actually, so they have in their criminal code a provision that says that where you assist someone else to die with their consent and you do it for selfless reasons, then you can be immune from prosecution. So there's kind of like an exception in their criminal code, which has been in force for, I think, since the 1940s. Again, I stand to be corrected on the exact date, but you are correct that it's been you know, people have been able to avail themselves of that particular carve-out or provision in the criminal code. But it's different from the Netherlands in the sense that Switzerland doesn't have a formalized statute specifically covering cases of assisted suicide and euthanasia. Like that was introduced in the Netherlands in 2002. But even in the Netherlands, obviously, the process of legal development is interesting because there were a couple of test cases where high courts in the Netherlands permitted in certain circumstances assisted suicide. And then building on those cases, there was a development towards a formal statute authorizing it, and so we see a similar thing happening in Canada as well with the Carter case and some other cases, and then it's sort of culminating in a formal statute, which clearly and carefully regulates the situation. And just to point out that might be one possible path that South Africa might take from a public policy point of view, either through the development of the common law, sort of piecemeal, and or eventually in a formal statute that comprehensively covers the topic.
Thanks. Now, one of the arguments that's advanced against the legalization of assisted dying is the slippery slope argument that you're going to permit more and more things. If you allow some assisted dying, you're going to allow more and more things, and eventually you'll end up at a point where you ought not to be. That is to say, allowing things that ought not to be allowed. Yes. And the Netherlands is often cited as an example of that, where there was initially permissibility just for a small range of cases, and then it's gradually extended. I'm always interested that the Netherlands is cited, but not any of these other jurisdictions where it has been legal. So can you tell me, are there any jurisdictions where it's been legal for quite some time, and there's also evidence of a greater permissibility other than the Netherlands?
I mean, that's a very good question. So I'm not aware of any evidence of, or any conclusive evidence of more permissibility in any jurisdiction where it's been available for a long time. So Oregon has also been available for a long time in the states. That's assisted suicide, and they've kept and in these states that legalize it, they keep accurate records, and they do regular surveys. And as far as I'm aware, there's no conclusive evidence that, and in Oregon, certainly, I mean, the circumstances in which you can avail yourself of assisted suicide have remained extremely narrow. So so there you have to be terminally ill, you have to have actually a prognosis of 6 months or less left to live. So that's actually very, very narrowly circumscribed cases in which you can avail yourself of it. And that hasn't seemed to have changed over the period that they've had that law in Oregon. Again, I can't say for sure. I would have to kind of do a comprehensive survey of all the jurisdictions and look at the empirical surveys. But right, as far as I'm aware, no. Yeah.
So what I think this shows is that when one makes that sort of claim about the inevitability of a slippery slope, one needs to be cautious, because it may be that you will get a shift in some jurisdictions and you won't in others, and there may be all kinds of variables that would explain that are not obviously apparent. But to constantly sort of point to the Netherlands as though all jurisdictions where legalization takes place would follow that path seems to me to be an oversimplification. It might be a cautionary tale for some people, but it doesn't mean all jurisdictions would follow that same path.
Right, absolutely. I mean, these are multifactorial things. And of course, the other thing with slippery slopes is that you need to show that the cases that are now allowed are cases that should not be allowed, and that the cases that are now allowed were caused by cases that were previously allowed. So, I mean, in the Netherlands, many people would say, well, the increase in scope of morally permissible assisted suicide is actually morally permissible and consistent with our principles and values, and this is we are not at a place that we don't want to be.
I think it's
yeah.
Sorry, yeah.
Go ahead. Go ahead, please.
So it's not so much that they're not a place where they don't want to be, but they're not at a place where they ought not to be. Because I think the whole point about the slippery slope argument is that you will come to accept things that you ought not to accept.
Right.
I mean, that's just a slight variant on what you were saying.
No, you're correct. That is correct. Yes. And then, of course, the thing with slippery slopes is that it really is an empirical matter, and you need to demonstrate with good evidence that there is going to be an increased risk of permitting these things leading to morally impermissible practices. And as far as I know, I mean, there isn't this kind of conclusive good evidence that this is the case. In fact, there is some evidence that the people who avail themselves of assisted suicide. So I suppose, just to take a step back here, I suppose what I'm also thinking about in the back of my mind is another argument that some people might make against legalizing it is that there's a risk of abuse, and that we can't put in place adequate safeguards to prevent this risk of abuse. And so I suppose one response to that would be, well, again, an empirical matter. So is it the case that there's going to be abuses that we can't control with adequate safeguards? And there's some evidence to suggest that there's this worry that the vulnerable will be taken advantage of if we legalize this. But there's some evidence in Oregon that the people who avail themselves of assisted suicide tend to be quite plucky people who are used to getting their way in life and are certainly not a soft touch and vulnerable, are basing their decision on the principle of autonomy. And so and so I suppose it illustrates the point that if we're worried about risk of abuse, then we need to pay careful attention to the evidence in our particular circumstances.
Yeah, I think you're quite right about that. I'd say a few other things about abuse. So often the choice is presented as keep it illegal and have no abuse, or legalize it and have abuse. And I think that's a false dichotomy, because there clearly are instances of abuse, even in jurisdictions where it's illegal. So you've had doctors like that Harold Shipman in the UK, who was killing a number of his elderly patients, undetected for a long time, and then finally uncovered. That's in a jurisdiction where it was illegal. So he was murdering people under the guise of medical treatment. People didn't pick up on it because it's not unusual for old people to die. But you didn't need a legal environment permitting euthanasia in order for a figure of that kind to be abusing his position. So that's the one thing to realize, is that there's a false dichotomy. Secondly, I think we should recognize that if one legalizes assisted dying, there will be some people who will abuse that. So the question is there going to be more than there would be in the alternative scenario? And not only that, but would there be so much more that it would offset the obvious advantages to legalizing? Yes. Because there are all kinds of things that are abused. Cars are abused, alcohol is abused.
Sure.
And when cars are abused, you often get young, healthy people dying as a result of it. So the way to stop deaths from car accidents would be to prohibit all car driving. You may then get, of course, deaths from horse-drawn carts. The way to stop those is to stop horse-drawn carts. But we think there is a societal value in having cars and other more forms of transport. And although they will sometimes be abused, the appropriate response to that is to try to curtail and limit the amount of abuse, to minimize it, so that we can at least get the advantage from those. And similarly with assisted dying, allowing people to, or not allowing, but forcing people to continue to live when they find their continued life a burden, is a real cost for a society to bear. And so it may be that we should allow, well, not allow, but tolerate some abuse while trying to minimize it.
Right. So permit and regulate to minimize the risk of abuse as much as possible, and maximize the benefits that it brings to people who want to avail themselves of it.
Yes, or try to at least balance giving these benefits to people and avoiding abuse, or avoiding as much abuse as possible.
Yeah. Do you think that there are specific concerns around legalizing assisted dying in South Africa, given the extent of inequality and lack of access to quality palliative care? Are those particular factors that that might mitigate against legalizing it in our particular circumstances?
It's a good question, because that's a common argument that's advanced by opponents of legalization in South Africa. I think there are two sorts, at least two versions here. The one is that if you did permit it, then poor and vulnerable people would be encouraged to take their lives or would have their lives taken. Perhaps it would slip from voluntary into involuntary rather than non-voluntary euthanasia. And I understand that worry, but as you say, the evidence from elsewhere in the world is that it does not tend to be the poorest and the most vulnerable people who elect to have the assisted dying. It tends to be better educated people, people with resources. So I'm not that worried, but if one were worried about that, one potential solution is to legalize and to have a sunset clause built into the legislation. So a sunset clause, as you well know, would be a clause that brought about the end of that legislation or the efficacy of that legislation by a certain date. So it's not that you'd create a law and it would remain on the books until it was actively defeated. You'd create the law and it would have an expiry date. It would need to be actively renewed if you wanted to continue. And so that avoids the presumption in favor of the law legalizing assisted dying from prevailing. And it also allows you to monitor what happens when you legalize to see whether it does lead to the negative consequences that the naysayers are suggesting would result. And then the other sort of argument, I suppose, is related to concerns about the poor and vulnerable is this lack of access to quality palliative care. And so that might be another reason. It's not that they would be bullied into it, but given the access to palliative care, they might be more desperate and want to see less assisted dying. And I suppose what I would say there is that the absence of palliative care is it's a terrible feature of our society, and not just our society. There are vast portions of the continent where people just don't have access to palliative care. And so I think it's a priority to be providing that. It's a very important use of healthcare resources. But in the absence of that, it might indeed be eminently rational for somebody to say, I'd rather die than continue in this condition in the absence of palliative care. So one thing that euthanasia, the legalization of euthanasia might do is it might actually focus people's attention and improve the availability of palliative care.
Yes,
people are far too complacent about that.
Yes, I agree. And so one thing to add to that is that these are not mutually exclusive goals. I mean, we should both be trying to broaden access to quality palliative care and give people the right to assisted dying if they choose to avail themselves of it. You should give people the choice. Exactly. Doesn't at all. Yeah. So I'm just conscious of time, Professor Benatar. But unless there's any other particular topic which you'd like to address or a particular point you'd like to make, perhaps I should just summarize briefly. I think there's one point that we neglected to make earlier that's been an underlying assumption in our conversation. Although we differentiated voluntary and non-voluntary euthanasia, and we differentiated the different kinds of questions that we can ask about euthanasia, what we didn't do was draw a distinction between active and passive euthanasia. And I should say that our discussion here has been really around active forms of euthanasia and active forms of assisted dying. Yes. So maybe worthwhile just briefly mentioning, if you assist somebody in passively bringing about their death, you are allowing them to die without you or their doing anything. So if, for example, somebody who had a terminal condition and got an opportunistic infection and they elected, let's say, not to take antibiotics so as to hasten the death, that's a passive way of bringing about your death or somebody else's death. We've been speaking there about active means, where you actually do something. You administer a drug, for example, or you give somebody a pill that they then ingest. And that's what we've been discussing. That is the more controversial case. The passive forms are deemed permissible and they are legal in many more places. Yes, that's correct. And so I suppose this could be a topic for another occasion, but there's an interesting question about whether anything turns morally on the distinction between actively killing and passively letting die. Because there are some philosophers who think that there isn't really it's a distinction without a difference. And if we can permit letting die, then we should also in certain circumstances, similar circumstances, permit actively actively assisting to die.
Great,
but I suppose that's
it is a topic for another conversation.
A topic for another conversation. Professor Benatar, thank you so much for your time. I've enjoyed the conversation. So just to briefly summarize that, hopefully it's become clear through our conversation the three distinct questions: is it morally permissible in any circumstances? Is assisted suicide and voluntary active euthanasia morally permissible in any circumstances? And if so, which? That's the first question. The second question, is it descriptively legal in South Africa and in other comparable jurisdictions which we've discussed, which is a separate and not a moral normative question. And the third question, whether or not it is morally permissible, ought it to be legalized in South Africa in our particular circumstances? But I suppose the same question could apply to another jurisdiction considering legalizing these practices where it isn't currently legal. So thank you very much, Professor Benatar. And
thank you. It was a very nice conversation.
I enjoyed it. Thank you very much.
Thanks.